Welcome to ICE at Your Door, what Minnesota business owners need to know. My name is Kimberly Hanlon, and I'm one of the founding attorneys of Lucier Legal, a Minneapolis-based law firm serving entrepreneurs. I'm also the author of the Minnesota Small Business Owners Legal Survival Guide, the plain English guide to the important legal aspects you need to know about when running your business. Of course, a lawyer would have a disclaimer, and here is mine. This presentation is for educational purposes and is not legal advice. That is to say that while I am a lawyer, today I am not your lawyer. I am not talking to you about your specific situation and giving you advice on your specific situation. There's no attorney-client relationship that is being formed here. Today is about clarity and confidence. You'll leave with a step-by-step plan for what to do if ICE agents come to your business or use your parking lot, how to spot valid warrants, how to protect your team, and how to reduce legal risk. We'll keep this practical and non-political. But before we begin, I also want to say that, to a certain extent, we are in uncharted territory. It's been hard for lawyers like me to predict outcomes because enforcement practices and on-the-ground interactions are not consistently aligned with established legal standards. That said, business owners who know their rights and the legal standards have often been able to protect their businesses, employees, and customers in these encounters. And that's my goal for you today, that you know your rights and what to do if ICE shows up at your door. There's a line where you have rights to robust protection and where you have less protection. That line is between the business's private spaces and the public spaces. In public areas, agents can enter like any member of the public. In private areas that are clearly marked and not open to the public, they need your consent or a judicial warrant. This distinction also applies to parking. Retail lots open to the public are generally treated as public-facing. A secured, posted lot not open to the public leans private. Public areas are open, while non-public areas require a judicial warrant or permission from someone in the business to enter. Here's a real-world example. CBS News reported that a Minneapolis restaurant called Ola Arepa declined agents' entry to the back-of-house part of the restaurant when agents lacked a judicial warrant, because access to the public dining area is not the same as permission to enter the kitchen. That's a correct application of the public-private rule. Posting an employees-only sign or a no public access sign and keeping doors closed to your business's private space signals that the space is non-public. The signs don't have to be pretty or expensive. A pen, a paper, and a piece of tape is all you need to post a sign that protects your space. Let's talk about what ICE can do in public spaces, even without your permission. Public spaces are areas of your business that are open and accessible to the general public, such as customer dining areas, retail floors or lobbies, public hallways, and customer parking lots. In public spaces, ICE agents may be present on the property without asking permission, stand, wait, or observe, approach individuals and ask questions, make arrests, conduct enforcement activity, and remain even if the owner or manager asks them to leave. ICE does not need a warrant or the business's consent to be in public-facing areas. The key legal reason is because the law focuses on expectation of privacy, not ownership. If members of the public are normally allowed in an area, it is treated as a public space for Fourth Amendment purposes. The business may ask ICE to leave a public area, but generally cannot require them to do so. Staff and management should not interfere, block, or obstruct ICE in public areas. The bottom line is if your customers can normally be there, ICE can normally be there, even without your permission. Be careful not to imply permission. Consent opens a door you can't close. ICE does not need permission to be in public spaces, but they do need permission or a judicial warrant to enter non-public areas. Once permission is given, It cannot be undone. So let's talk about implied consent. Consent does not have to be explicit. It can be implied by actions or words, including saying sure, okay, or go ahead, stepping aside or holding a door open, escorting agents past an employees-only sign, answering questions in a way that assume access, like they're probably in the back, or failing to clearly say no when access is requested. It may not seem like it should be this way, but silence or hesitation can be interpreted as consent. This is what consent does. It eliminates the warrant requirement. It allows ICE to enter any and all private areas, and it cannot later be revoked. Evidence or arrests made after consent are generally lawful, even if consent was misunderstood or given by mistake. Once the door is open, you cannot close it by saying, "I changed my mind." Don't be combative, but this is one place where you need to speak up and be assertive. The safe default response needs to be, "This is a non-public area. I do not consent to entry. Do you have a judicial warrant?" Repeat as needed. Do not explain, justify, or argue. In a minute, we're going to talk about what to look for in a warrant. But first, let's talk about what ICE can and cannot do with a valid judicial warrant. With a valid judicial warrant, ICE may enter non-public or private areas of a business listed in the warrant, or the residence itself for a home. Search only the locations described in the warrant. Arrest only the person named in the warrant, if it is an arrest warrant. Use reasonable force necessary to execute the warrant, and seize items specifically authorized by the warrant. The business may not block or interfere once a valid judicial warrant is presented. Even with a judicial warrant, ICE may not search areas not named in the warrant, detain or arrest people not named in the warrant, absent some other independent legal cause, conduct a general or unlimited search, use the warrant as permission to search unrelated records, devices, or people, or ignore the scope, limits, or location described in the warrant. A warrant is not a blank check. This is your role when a judicial warrant is presented. Ask to see the warrant. Read it carefully. Look for who issued and signed it, and what the warrant is authorizing. Do not consent to anything beyond what the warrant authorizes. Do not assist, but do not interfere. And document the interaction and contact legal counsel. Here's the bottom line. A judicial warrant opens a specific door, not every door. ICE may enter only where the warrant allows and go no further. This is what a warrant from a judge or judicial warrant looks like. It has the court issuing the warrant at the top, and the signature will be a judge's signature. Before a judge will issue a judicial warrant, law enforcement must show 1. Probable cause. This means specific facts showing a reasonable belief that a crime has occurred, or a specific person is subject to arrest, or evidence of a crime will be found in a specific place. 2. Supported by sworn evidence. The request must be supported by a sworn statement, just like how you would have to be under oath if you were to testify before a judge. Officers are legally accountable for the truth of what they submit. 3. Stated with particularity. The warrant must specifically identify the place to be searched and or the person to be arrested and or the items to be seized. No general or open-ended authority is allowed. 4. Before a neutral judicial review. A judge or magistrate judge, not ICE, decides whether the standard is met. Here's the bottom line. A judicial warrant is issued only after a judge independently decides that specific sworn facts justify a specific intrusion, and it allows nothing more. Here are the 2 administrative warrants that ICE uses. You can see at the top that they are not issued by a court, and the person signing them will be an ICE agent. This is what an ICE administrative warrant allows. It authorizes ICE to seek the arrest of a specific person. It allows ICE to ask questions and request cooperation. It allows ICE to make arrests in public spaces. It allows ICE to request consent to enter private areas. This is what an ICE administrative warrant does not allow. It does not allow entry into non-public areas of a business or home. It does not override property rights. It does not require cooperation. It does not permit searches of private areas. And it does not substitute for a judicial warrant, no matter what they are trying to say on television. Administrative warrants are not issued by a judge and do not authorize forced entry. Here's the bottom line. An ICE administrative warrant allows ICE to ask. It does not allow ICE to enter, search, or force access to private spaces. Form I-9 inspections, which are done with a Notice of Inspection, or NOIs, is not the same as unannounced operations. Not every ICE contact is a raid. With a Notice of Inspection, you typically have at least 3 business days to respond. ICE guidance also recognizes a 10-day window to correct technical violations, and substantive violations may be fined. I recommend that you build a neutral, non-discriminatory internal audit process now, so you're ready. Here's what to do in the moment when ICE comes into your business. 1. Stay calm and professional. Call legal counsel or your point person. The most important first move is slowing the situation down. Panic leads to accidental consent or over-cooperation. Only the designated point person should engage with ICE. Other staff should be trained to say, "Please wait here while I get our manager." Calling legal counsel early is not obstruction. It is risk management. 2. The point person needs to meet ICE in your public area and request ID and a judicial warrant. Always meet ICE in a public area. This preserves the public-private boundary. Ask for identification and ask, "Do you have a judicial warrant?" This question does 2 things. It asserts your rights without arguing, and it determines how much authority ICE actually has. You are not accusing them of wrongdoing. You are simply asking them to show their legal authority. 3. Do not consent to private area entry without a judicial warrant. This is the most legally sensitive step. Employers have no obligation to consent to entry into non-public areas, even if ICE is looking for a specific employee. Silence, hesitation, or being helpful can be treated as consent. Managers should use a short, firm script and repeat it if necessary. Refusing consent is not obstruction. It is a constitutional right. 4. Designate an escort and document names, badge numbers, time, and actions. Documentation is protective. Assigning an escort does not mean you are assisting ICE. It means you are monitoring compliance. Keep a log of what is happening as it happens. Who arrived, what they asked for, what documents they showed, and what areas they entered. This protects the business and preserves evidence if the scope is exceeded. 5. Protect workers' rights. Employers are not required to help ICE identify, locate, summon, or produce workers. You do not have to answer questions like, "Who works here?" "Who is undocumented?" or "Where is John?" You should not lie. That is a federal crime. But you may say, "I can't help with that," or simply repeat that you do not consent to interviews in non-public areas without a judicial warrant. At the same time, employers must not coerce workers into speaking, producing documents, or attending interviews. Do not instruct employees to answer questions to clear things up. The line is this: not assisting is lawful. Actively hiding, lying, or obstructing is not lawful. Let ICE do its own investigation. You can just keep saying, "I can't help you with that." 6. If they present a valid search warrant, then follow scope of that warrant. When a valid judicial warrant is presented, the business must comply, but only within the warrant scope. You can shadow agents politely but consistently. Do not volunteer access beyond what is listed. If documents are seized, request copies or document exactly what was taken. Compliance with a warrant is required. Expanding the search is not. 7. Afterward, create your incident log, preserve video, and contact your legal counsel. After ICE leaves, preserve everything: security footage, logs, emails, and notes. Do not debrief employees in a way that pressures them to disclose what they said. Contact your legal counsel right away. Even if everything appeared orderly, review is important because scope violations often aren't obvious in the moment and may not be apparent to someone without legal training. If someone ICE is chasing runs into a non-public area of your business, or your home for that matter, the law does not require you to help ICE get them. Here is what you should do. Stay calm and do nothing to escalate the situation. Clearly state that the area is non-public. Do not consent to entry without a judicial warrant. Allow ICE to decide their next step. That's their job, not yours. Document what happens and call your legal counsel. This is what you should not do. Do not encourage or direct the person to flee into your private space. Do not hide the person or move them. Do not lie to ICE. Do not physically block or interfere with agents. Do not go get the person for ICE. The legal line is simple. You may decline to assist. You may refuse consent. You may remain silent, but you may not obstruct or actively seek to harbor. Until ICE has a judicial warrant, private space stays private. In any encounter, you don't have to help ICE. You just can't get in their way. Parking lots cause a lot of frustration because they feel private. But the law looks at access, not ownership. If a business parking lot is open to customers or the general public, ICE may be there without permission and without a warrant. That includes standing, waiting, observing, questioning people, and making arrests. The business may ask ICE to leave, but generally cannot require them to leave a public-facing lot. The key distinction is public versus non-public. A customer parking lot is treated as a public space. A restricted lot, such as a gated, staff-only, or clearly posted, no public access area, is treated as private space. ICE may be told to leave those areas unless they have a judicial warrant. Having signage in a private parking helps identify it as a non-public area. One important local note. In Minneapolis, ICE is prohibited from staging on city-owned lots and ramps, but that rule does not apply to privately owned restaurant parking lots. Here's the bottom line. You usually cannot keep ICE out of a customer parking lot, but you can control what happens beyond it, and you are never required to help ICE do its job. Having documented internal policies in your business and training your staff helps protect your business and mitigate risk. I recommend you adopt manager scripts, warrant review protocols, employee rights handouts, an employees-only signage strategy, training materials, and a process for what to document during and after an encounter. Let's take everything we've learned today and apply it to some common scenarios you might encounter. The first, agents waiting in your open parking lot. What do? Say to your staff, operations continue. Use designated entrances. If approached, employees may remain silent and request counsel. The next scenario, agents request access to the back of house in a restaurant. You say, back of house is non-public. We don't consent to entry without a judicial warrant. Then let ICE continue to act in the public spaces without assisting and without interfering. The next scenario, 2 agents in your lobby with an administrative warrant. You say, welcome. For everyone's safety, we meet in this lobby. May I see your IDs and any judicial warrant? The agent says, we have an administrative warrant for an employee. You say, we do not consent to entry into non-public areas. If you obtain a judicial warrant, we'll comply within its scope. Then let ICE continue to act in the public spaces without assisting and without interfering. The last scenario, agents present a judicial search warrant. You say, we'll comply within the scope of this warrant. I'll notify our counsel and assign escorts. We'll need copies of anything seized. Then shadow ICE without assisting or interfering to make sure they stay within the bounds of the authority granted in the warrant. If they try to exceed the authority granted by the warrant, say, "We do not consent to searches beyond what the warrant authorizes." What creates unnecessary liability for the business? Most employer liability during ICE encounters is self-inflicted. Common mistakes include consenting to entry into non-public areas without a judicial warrant, volunteering information about workers, schedules, or locations, producing employees or directing ICE to specific individuals, coercing workers to answer questions or produce documents, destroying or altering records, including I-9s or video, or lying about something. Never lie to a federal agent of any sort, because that's a federal crime. Refusing consent, remaining silent, and asking for a warrant are not liability-creating actions. Being helpful beyond what the law requires often is. Here's when it may be appropriate to pause operations temporarily. A short, controlled pause can be appropriate when it's done for safety and order, not to obstruct ICE. Examples where a temporary pause makes sense. Customer or employee safety is at risk. ICE activity is disrupting normal operations. You need time to identify the correct decision maker or contact legal counsel. Or agents are executing a valid judicial warrant. If operations are paused, keep it brief and neutral. Do not move employees around to avoid ICE. And do not announce the pause as resistance or protest. Pausing for safety is lawful. Pausing to interfere or hide people is not. And here's when to contact legal counsel immediately. Call counsel right away if any of the following occur. ICE presents a judicial search or arrest warrant. Agents ask for employment records, I-9s, or personnel files. ICE attempts to enter non-public areas. An employee is detained or arrested at the workplace. There is confusion about the scope of authority being asserted in a warrant. Or a manager feels pressured to just cooperate to make it go away. Early legal guidance helps prevent scope creep, protects worker rights, and reduces post-incident exposure. Here is my closing takeaway. Staying calm, limiting cooperation to what the law requires, and calling counsel early protects both workers and the business. Most problems come from doing too much, not from doing too little. And with this recording, I also have bonus materials for you to use, including a guide for business owners and managers, a warrant ID guide, and a Know Your Rights guide for employees. I'm happy to take any questions. You can reach out to me and I'll help you get the clarity you need. And if you think you may have a situation you want to run past a lawyer, reach out and I will be happy to have a complimentary discovery call to see how I could help you. I would be happy to visit with you about whatever is on your mind. We've come to the end of our time together. Thank you for your time and attention today. I wish you all the very best in your business endeavors.